What is the insurable interest? Right, short note on insurable interest. Insurable interest means a legal or financial relationship between insured and the subject matter of insurance, such that insured will suffer a financial loss if the insured events occurs and will benefit from its safety. Judicial definition: to constitute an insurable interest, the assured must be so situated that the happening of the event on which the insurance money is to become payable would cause him loss or prejudice. Case laws in case Lucina versus Crawford, 1806 2 BOS and Paul NR 269. In this case, fact is, commissioners of the British Navy insured enemy ships captured during the war. At the time of the insurance, the ships had not yet been condemned by a prize court. Ownership had not legally passed to the crown. The ships were lost before condemnation. Insurers denied liability, contending that the insured had no insurable interest. The issue: what constitutes insurable interest? Whether a mere expectations or moral interest amounts to insurable interest. Then decisions of the court held that insurable interest must be a legal or equitable interest, not a mere hope. A person must stand in a position where he benefits from the safety of the subject matter or suffer loss from its destruction. Since the crown had no legal title at the time of insurance, there was no insurable interest. The policy was declared void. Legal principle established: insurable interest requires a legal or equitable relationship. Mere expectation or moral certainty is insufficient. Foundation definitions of insurable interest in common law. Now, the necessity of insurable interest. It prevents the wagering contracts, discourages the insurance fraud, ensures that the insurance is for protection, not for profit. Time when the insurable interest must exist: life insurance at the time of taking policy, and the fire, marine and other insurance at the time of loss. In case of life insurance, insurable interest must exist at the time of taking the policy, need not exist at the time of death. Case laws: Dalby versus India and London Life Assurance Company, 1854, 15 CB 365. Facts: the Dalby took a life insurance policy on the life of the Duke of Cambridge. Dalby had no family relationship, no pecuniary or legal interest in the Duke's life. Dalby later assigned the policy to another person. On the death of the Duke, the assignee claimed the policy amount. The insurer challenged the claim for lack of insurable interest. Issue: whether insurable interest must exist at the time of loss, whether absence of insurable interest at maturity invalidates the policy. Decision: the court held that in life insurance, insurable interest is required only at the time of taking the policy, not at the time of death. Assignment of a valid policy is lawful even if the assignee has no insurable interest. However, since Dalby himself had no insurable interest at inception, the policy was void. Claim was rejected. Legal principle established: in life insurance, insurable interest is required only at inception. A valid policy can be assigned. A policy without insurable interest at inception is a wagering contract. Now, fire insurance, fire, marine and other insurance. Insurable insurance must exist at the time of loss. Now, in that case, the case law is Macquarie versus Northern Assurance Company Limited, 1925 AC 619 HL. The Macquarie Fact is, Macquarie owned almost all shares of the company. The company owned timber stock. Macquarie insured the timber in his own name, not in the company's name. The timber was destroyed by fire. The insurer reputed the claim on the ground of no insurable interest. Issue: whether a shareholder had an insurable interest in company property, whether ownership of shares equals ownership of company assets. Vision: the House of Lords dismissed the claim, held that the company is a separate legal entity. Shareholders have no legal or equitable interest in the company asset. Macquarie suffered no direct legal loss, hence he had no insurable interest and the policy was void. Legal principle established that the shareholders do not have the insurable interest in company property. Company property not equal to shareholder property. The insurable interest must relate to legal ownership or liability. So, no legal interest, no insurance, no loss possibility, no protection, no separations of identity, no recovery. Insurance reward risks, not speculations. So, examples of the insurable interest is: owner has insurable interest in his house, creditor had insurable interest in debtor's property, and to the extent of debt, and partner has the insurable interest in partnership property. Example: like consequences of absence of insurable interest, contract becomes void. If there is an absence of insurable interest, the contract becomes void. Policy is treated as a wagering agreement. No claim can be enforced. Statutory recognition: insurable interest is recognized under the Made in Insurance Act 1963, General Principles of Indian Act, Indian Contract 1872. Conclusion: insurable interest is an essential element of a valid insurance contract. It ensures that the insurance remains a contract of indemnity or protection and not a gambling transaction. Without insurable interest, an insurance contract is void and unenforceable.